Hello, everybody. Here we are again with Elmarco Talks. It's my pleasure to moderate this one because we will talk about key insights from the Foshan Lepton case and China's patent litigation framework. This is the topic. This is the name. My name is Miloslav Masopust. I'm CEO of Elmarco. And of course, intellectual property is something what I deal with not every day, but every night because I dream about that, of course. Intellectual property for Elmarco is a real property, and I believe that it's real property for everybody, every company in the world. And that is why we want to share some information and our experience about a case we had recently in China, because China and IP, that's a question mark topic. And that is why we did something what we want to share with you. I'm more than happy to introduce to you my two colleagues for today. It's David Haleš and Bruce Tang. These two guys helped us and supported us in the case with Foshan Lepton in China's court. And David will start with his presentation. David Haleš is he joined Musil company in 2005. And I know him from, I believe, 2009 or 10 or something, David. So we know a long time each other. Bruce, he looks very young, but he's super experienced IP person. He studied in Germany. He studied engineering communication and let's say technical topics. And he is very experienced in IP. So, Bruce's presentation will follow to David's one. So, David, are you ready to start with your presentation?
Yeah, I'm ready.
So, let's do it.
Okay, thank you. So here we are. I will start my presentation with simple overview of various types of protection of intellectual property, because different tools are sometimes confused. The applicants sometimes talk about word patent or patent trademark, and so I would like to start with short explanation of different kinds of protection. Then I will come to the details of the Elmarco's patent, and then to details of the case in the China. Then my colleague will continue because he's the one who learned the case. And I will just technical support to him, so he has more ideas to share with us for the case. So generally speaking, there are various types of protection of intellectual property. Each has its own specifics, and how I said before, there are sometimes confused. Most important are patents, but sometimes, which may be sometimes supplemented by supplementary protection certificates. And other types of protection are electrode, trademarks, designs, and other minor tools. As regards patents, the granted patent provides its proprietary legal protection, or in fact legal monopoly for the invention. No one may, on the given territory, manufacture, offer, or sell product or process that is within the scope of the protection. But at the same time, it must be noted that the grant of a patent does not automatically mean that you are free to operate in the given territory. Even if you have a granted patent, you still can infringe rights of somebody else. So granted patent is not automatically freedom to operate search. Yeah? There are different kinds of patents. Patents are national or regional, and there is no worldwide patent. Sometimes somebody calls and I want worldwide patent, but nothing like that exists. Sorry, my fault. The conditions for granting a patent are essentially the same all over the world. The invention must be new, must be inventive, must be industrially applicable, and at the same time must be outside the exclusions from patentability. Whether these conditions are met or not is examined by authorities during substantial examination of the patent application. So, yeah. The term of protection of granted patents is 20 years, and how I said before, the supplementary protection certificate can extend the protection up to 25 years. Okay, there's some technical problems here, so just give us a minute, please.
Sorry to everybody for technical issues. We were training, but we were not training enough. Well, maybe this is the reason is that I am sitting in Miami in the United States.
Okay,
Haleš is sitting in Elmarco.
Do you hear me?
Yes, but there is echo, David, unfortunately.
Okay, it's okay. Sorry for the problems. Now utility models. Sometimes called small patents or petty patents. Utility models are specific cases because conditions parameters of the utility models are different in different countries. Not all countries even know utility models. It's full stuff from Europe, and some other countries know it, but not all. As by the patent, the requirement for registering a utility model is novelty, inventive step, and the applicability of the technical solution. However, models are usually registered without conducting a substantial search, which makes them cheaper and quicker. There are exceptions, for example, Poland or Portugal, where they do single searches for patents. Utility models are limited rather because they can't protect process or methods or biological material. They can protect just devices or machines or products. Yeah, we have the one spec. Sorry, we will try to remove and continue. Yeah, hopefully it will be fine now. Yeah. I hope you hear me. We will see. So I will start where I ended, and we will see how it works. So utility models are generally limited to protection of industrial products and devices and cannot be used for protection of metals, processes, or biological material. Utility models are very good tool for strategic innovations because they can be combined with protection of patent and the utility model, which is quick and cheap, can bridge the gap between current patent application and granting of the patent. But in such case, the application of patent and utility models and the same invention must be filed in the same way. The term of protection of utility model is typically between 6 to 2 years, and the most typical case is 10 years. Trademarks. Trademarks are legal protection of word, phrase, or design symbol, something like that, which identifies products or services from one company, from products or services from other companies. Trademarks may be national, regional, or international. Trademark must be distinctive, so it must be possible to identify the products for other products in the same field, but cannot be descriptive for the different services. Every trademark is always registered for specific products and services for which it is to be used. There is a number of different kinds of trademarks, and the most frequently used are the different trademarks. Sometimes, although unregistered designation may gain similar rights as registered trademark. Term of protection of trademarks is unlimited, but the basic protection is for 10 years, and it can be extended again and again up to infinity. Design or registered design protects the appearance of a whole product or part of it. It typically protects shape or appearance of a new product, but it can be also used for protection of typographical fonts, pictograms, or similar graphical items. Designs do not protect internal structure of the machine or technical function of the machine, just the appearance. So the term of protection is 5 years, but it can be repeatedly extended by another 5 years, up to 25 years in total. Now we finally come to the case of Elmarco patent covering wire or cord electrode. For protection of this unique technology, the patent was obvious choice. We filed a patent application in July 2007, and this application contained 54 claims just to cover all possible variants or setups of the machine, of the electrode, and and the process to how to spin from this electrode. The Czech Industrial Property Office raised no objections during the substantial examination, and so in March 2009, Czech patent was granted. The procedure took approximately 20 months, but it was still relatively fast and smooth. After that, in the priority period, we filed international application and Taiwanese application. The Taiwanese application must be filed separately because Taiwan is not member of Patent Cooperation Treaty, and so it is not covered by the international application. The Taiwanese patent was granted in May 2012, and it is still valid nowadays. As Elmarco is based in the Czech Republic, the international search for the international application was carried out by the European Patent Office. Unfortunately, the European Patent Office issued a negative written opinion, according to which none of the claims was new nor inventive. And the European Patent Office cited this document of a Helsa company, where something like spinning some wires may be found if you want. But the setup and the movement of the wires of the electrodes are different. So we had to amend the patent claims of Elmarco application by introducing a description of the different movement of the wire electrode with regard to the substrate on which the nanofibers are deposited. It is clear that in the case of Elmarco, the wire electrode is static or moves in the direction of its length, while the distance between the wire electrode and the substrate is constant during the whole process. In the case of Helsa document, the wires move in a direction perpendicular to its length, and the distance between the wire electrode and the substrate changes in time. So after this amendment, we also requested or filed a demand for international preliminary examination. European Patent Office examined the case, and in view of amended claims and our argumentation against the Helsa company document, issued an international preliminary report on patentability, according to which all new claims were again new and involved an inventive step. So the international application later entered national phases in several countries and regions. 10 national and 2 regional patents were granted eventually. Most of them are still valid nowadays. The European patent was subsequently validated in 17 member states of European Patent Convention, EPC. The Eurasian patent covers all member states of this organization, which are Russia and some post-Soviet republics. When entering a national phase in China, we closely cooperated with colleagues from China Patent Agent, and the Chinese patent was granted in March 2012 eventually. As we used claims amended in the international phase, the proceedings went quite smoothly with no substantial problems. But 8 years later, together with the COVID crisis, also came this information on possible infringement of this patent from side of company Foshan Lepton in China. This company apparently offered and supplied machines for needleless electrostatic spinning, but they had 2 variants of these machines. First was based on use of spiral electrode, which they even tried to protect by a patent, but this patent was never granted, and this is one of the figures from the patent. And the second variant was a machine which was supplied without any electrode, but its manual proposed mounting of a spinning electrode in the form of a wire. So this represents an inducement of infringement or indirect infringement. And the infringer provides means relating to an essential element of the protected invention, and which serve for implementation of the patented invention. In December 2020, we also found a footage of a device of another company than Foshan Lepton, clearly using a spinning electrode in the form of a wire, static or movable, which appeared in a TV show in Hong Kong. This is a short clip from the footage, and it is clear that there is wire electrode and something applies polymer solution on the electrode, and the polymer solution is spinned, and the nanofibers just travel from the spinning electrode upwards to the substrate. So we later also found that Foshan Lepton machines were commonly sold on Alibaba.com, and so we decided finally to take any action against the infringement. At the end of 2020, we were able to obtain photos and videos directly from the Foshan Lepton factory, showing machines which clearly infringe Elmarco's patent as they contained wire electrode. At the beginning of 2021, we sent warning letter to Foshan Lepton, but we never received any reply. Therefore, we continued to collect and secure evidence of the infringement and notarization of this evidence to make it usable at the possible court proceedings. At the same time, there was question of evaluation of damages caused to Elmarco, and after a decision, we set these damages at 5 million Chinese yuan. Subsequently, in November 2021, our colleagues from China Patent Agent drafted and filed a lawsuit with the Guangzhou Intellectual Property Court. The court accepted the lawsuit and subsequently set a 1-month cooling off period for a possible out-of-court settlement. After this period and after some preparation, actual court proceedings began. The first court hearing was summoned in May 2023. Subject of this hearing was particularly cross-examination of evidence and arguments submitted by both parties, Elmarco as plaintiff and Foshan Lepton as defendant. It is also worth to note that under Chinese practice, the court expects that the parties file their observations with the court within several days after the hearing, which is quite a different approach than that of Czech and European courts. Approximately 7 months later, in December 2023, the IPR court issued a decision in favor of Elmarco, according to which Foshan Lepton infringed Elmarco's patent. The court awarded to Elmarco, or the compensation awarded to Elmarco was the full price requested in the lawsuit. So, as expected, Foshan Lepton appealed the decision in the given period. The Court of Appeal subsequently initiated both appeal proceedings and mediation proceedings, the aim of which was to reach an agreement between Elmarco and Foshan Lepton under the supervision of the court. We filed a response to the appeal and at the same time initiated negotiations between Elmarco and Foshan Lepton on possible mediation agreement. Foshan Lepton countered by filing invalidation request against Elmarco's patent. The request was based again on a document of Helsa company, but different one this time. And according to Foshan Lepton's action, this document was novelty destroying for the Elmarco's patent, and also Elmarco's patent lacked clarity, and the description was not clear. So in our reply, we decided to slightly amend independent claims of Elmarco patent, but without any limitation of the scope. In the same time, we also cooperated with our colleagues from China Patent Agent and prepared a list of key points for a possible mediation agreement with Foshan Lepton. One of the points was also a withdrawing of the invalidation request. So at the moment, we have 3 different proceedings running at the same time. The Patent Examination Board summoned very quickly first oral hearing and subsequently rejected the patent invalidation request and confirmed the validity of the patent. So the first proceeding was ended successfully. In the meantime, we continued to try to reach an agreement with Foshan Lepton and conclude a mediation agreement. For some time, it seemed that we were able to find a substantive compromise, but suddenly representatives of Foshan Lepton in December 2024 changed their mind and proposed amendment of the settlement, which was not acceptable for Elmarco. Therefore, we asked the judge of Court of Appeal to terminate the mediation proceedings and continued appeal proceedings. The court very quickly issued also its decision, in which it upheld the first instance decision in its entirety, including the decision on infringement and also value of the compensation awarded to Elmarco. As representative of Foshan Lepton complained during management proceedings, about the financial situation, we decided to file an enforcement application in January 2025. Upon this application, the court assigned enforcement officer to investigate Foshan Lepton's financial situation, to identify assets that may be seized or garnished to enable payment of the compensation awarded. So this is the point where are we now. And I will give the word to my colleague Bruce, because, how I said before, he was the face of the case and he made all the work. So Bruce, it's yours now.
Well, thanks, David. I try to share my screen. It seems that my camera doesn't work well. Can you see me on screen?
We can't. So, well, just share your presentation and we will see the presentation, not you, unfortunately.
Yeah, always technical problems. Anyway, we'll go. Okay, thank you very much, David. Thank you very much, Masopust, for your kind introduction. And I knew that Elmarco puts a lot of efforts in IP development and IP protection. So it's really my great honor to be here for this wonderful Elmarco talk session, particularly related to intellectual properties. My name is Bruce from China Patent Agent. I have an experience of 17 years for handling IP cases. And today, I'm proud to provide a brief overview of the patent litigation framework in China and share some key insights about the recent Foshan Lepton case we handled for Elmarco. Firstly, I would like to mention that China has now actually gradually become a rising hotspot for patent litigation, not only attracting the domestic patent holders, but also international patent holders. On this slide, I have listed several companies which are involved in patent litigations in China, including Ericsson, Intel, KPN, Volvo, Bayer, Samsung, and also Sony. By the way, some of those international companies are the clients of our firm, and I personally represented some of them. And a note, for example, for the patent litigation between international companies was the case between Apple and Qualcomm. And Apple is the biggest smartphone company, and Qualcomm is its cheap supply. And Apple utilized some technologies developed by Qualcomm, but they had some disagreement on patent licensing policy and patent fees. So since China is one of the most important markets for both companies, Qualcomm filed a patent court case in a court in the south of China, and the Chinese court supported Qualcomm and granted a preliminary injunction preventing Apple from selling some older model iPhones. So shortly after that, there is a settlement, and this case shows the importance of China as a legal battleground for international companies. And also this slide shows the case handled by the Supreme Court of China. I mean, these cases are all associated with patent infringement. And as you can see, annually, the Supreme Court handles several hundred patent infringement cases, and among them, 5 to 10% are foreign party related. I mean, for the highest level of court, this number is huge. By comparison, for example, the U.S. Supreme Court processed patent cases, one patent cases like every several years, and in most years they do not handle even one patent case. And also,
Bruce, we don't see the presentation moving. Like there is just the first page of the presentation still.
oh, sorry, wait a moment. I try again.
Yeah, now you are on slide 4.
Yeah, slide 4, yes.
Yeah, but can you open the presentation, like really, like make it presentation, not only the, like to make it slideshow, please?
Wait a moment. Yeah. Can you see it?
No.
Slide 4. This is slide 4.
No, we still have it like.
Okay, I stop screen share and try again. Yeah. Can you see the screen now?
Yes, sir. Thank you. Thank you.
Let's go. I just mentioned this slide 4 about the number of the patent cases handled by the Supreme Court. Anyway, here this graphic shows the winning rate of the foreign patent holders in China. As you can see here, at the level of Supreme Court, the winning rate of the foreign patentees could even reach as high as 80% in some years. And at some lower level courts, this winning rate could be even higher. So this is a statistic I made before. It shows that for the American companies, they in the first instance patent infringement cases, they can win more. The winning rate of those companies could reach more than 86%. Okay, so this slide shows the patent system for handling patent infringement cases in China. And typically, the first instance is handled by some IP courts and other competent intermediate courts, and the whole proceeding could last for 1 to 2 years. And if one party, the accused infringer or the patentee, or maybe both parties are not satisfied with the first instance judgment, then they could file an appeal with the IP tribunal of the Supreme Court. That is the second instance, and the second instance could last for 1 year. And then if further, I mean, although the second instance is a so-called final adjudication, that means once a party receives the second instance judgment, that judgment would come into force immediately. But still, the legal system in China provides a further venue for remedy. That is called a retry petition. But in most cases, the retry petitions will be rejected by the retry tribunal of the Supreme Court. Okay, this slide shows the most popular jurisdictions for patent litigation in China. As you can see, the coast provinces with more developed economy handled the largest number of patent cases in China, particularly in 2 provinces here marked in dark red. That is the Jiangsu province and the Guangdong province. And in fact, we also filed our Lepton case in this province, I mean the Guangdong province, as David mentioned, the Guangzhou IP court to be more accurate. And for each of those provinces handled several hundreds of patent infringement cases every year. Also, an accused infringer could challenge the validity of an asserted patent by filing a patent invalidation request. And China adopts a so-called bifurcated patent system like that in Germany. That means different tribunals handle infringement proceedings and invalidity proceedings, and the infringement proceedings are handled by civil courts, while the invalidity proceedings are handled by the Patent Re-examination Board, which is a branch of the patent office. And the proceeding, invalidity proceedings last typically for 5 to 8 months, which is pretty fast. As far as I know, for example, in Germany, the Federal Patent Court may handle a nullity case for nearly 2 years. Okay, so if one party is not satisfied with the decision made by the Patent Re-examination Board, then he can file an appeal with the Beijing IP Court, or a further appeal with the IP Tribunal of the Supreme Court. So that's the basic framework for patent litigation. And then I would like to go to the milestone case between Elmarco and Foshan Lepton. This is a timeline, and as David has detailed the information about this case, I would not like to repeat the same, but still I would like to mention the great achievement we acquired. That is a permanent injunction and a compensation of 5 million RMB. That is actually the upper limit of statutory damages. And another news, another good piece of news that we received on, the day before yesterday, is that this winning case was also reported by the Xinhua Net, which is one of the most influential state-owned news agencies in China. Maybe later I can send it to you. And this report of our winning case actually demonstrates the importance of this case and also the efforts of China for patent and IP protection. So actually in this Lepton case, there are some interesting points, but due to the time restriction, I would like to mention 2 of them. And if more time left, I would like to mention 1 more. We'll see. So firstly, it is about the evidence collection. So in China, we do not have the American style of evidence discovery mechanism or similar. So as a patentee, we need to take a heavy burden of proof. For example, in particular, we needed to show the court the special structure of the infringing product, so that the court could make a decision on whether there is a patent infringement. Usually, for small products like for end consumers, it should not be a problem. Definitely, we could buy a sample infringing product like a smartphone or a water bottle. But for large scale machinery, like in this case, in this case, as you can see from this picture, well, the infringing product is actually a nanofiber production line. It's pretty huge, and also even the infringing product is also quite expensive, and they may have some special channels for selling and buying. So it's really a challenge to get an example of the infringing product. That's why David and our team had deep discussions about how to get the information about the infringing product. And finally, we decided to conduct a so-called covered evidence collection at Lepton's premises, so that we could secretly gather the information about structures and maybe some materials about the infringement. And well, for covered evidence collection, it's sure we need to first establish a covered identity. Usually, it's always safe to have such identity as a potential buyer, and then we determine the optimal timing to visit Lepton's premises. Actually, we selected the date is December 30th. So you might be curious why we selected December 30th. That is because it's just 2 days before the New Year holidays, and usually, at that time, the management of a factory or the employees could be, more relaxed, just 2 days before the holidays. So that time could be, good for us to collect, materials and information, maybe also, take some pictures. And further, we also designed some specific questions for verifying infringement and assessing damages. For example, questions like, which component is spinning electrode, or which component is the collecting electrode, and how about the sales volume, and also the sales price, and also maybe some clients of that infringer, the Foshan Lepton company. So with those preparation, we visited the factory of that infringer, and our investigator succeeded in taking photos of the infringing products and recording conversations, and he even succeeded in getting a video, actually several video clips showing the spinning process of the infringing products. So that's nice. Actually, this slide shows some materials that we got from that evidence collection, and this one is a screenshot for the communication with the infringer, and here is a business card of the sales representative of Foshan Lepton. This is a brochure of Lepton introducing its products and the company itself. And this is a picture of the factory. Actually, we take dozens of such pictures. And this is a frame from a video clip showing how the infringing product works. And the last picture is a piece of nanofiber produced by the infringing product. So with those collected materials and evidence, actually, we were ready to file a patent infringement case. While one of the biggest concerns about filing patent infringement cases in China is the low compensation. And in this case, we also faced such a challenge. So we need to be inventiveness when claiming high damages. So typically, there are two ways to assess compensation in patent infringement cases. One is based on the infringer's profits acquired through infringement. And the other is based on the patentee's losses incurred as a result of the infringement. And in this case, our choice is to use the patentee's losses as a basis for compensation. The reason is that there is a substantial price difference between the patented products and the infringing products. Suppose the selling price of the infringing product is 1 million and the patented product is 10 million. If we take the infringer's profits as a basis for compensation, then the compensation is at most 1 million, for example. But if we choose the patentee's losses as a basis for calculation, then the calculated compensation could be far more than 1 million. So we come to the next page. Here we choose the formula for damage or compensation calculation, and the first line formula is typically used in a patent infringement case for compensation calculation. That is to the losses equals patentee's profit per device multiplied by number of devices sold fewer due to the patent infringement. In practice, however, maybe since the profit per device could involve business secret, so sometimes we do not ask the patentees for such information, and also it could be even a challenge to get the value with respect to the number of devices sold fewer due to patent infringement. The reason is that there could be several players on the market. For example, one client purchased 10 devices from Lepton, but that doesn't mean if that client did not purchase 10 devices from Lepton, it would have purchased 10 devices from the patentee. I mean, that client could purchase devices from other players, or it may even cancel the purchase plan, right, due to the high prices and maybe some other some other factors. So in this case, due to the difficulties in obtaining the parameters, those two parameters, we further developed a formula for calculation of compensation that is shown here. The approximately equals the selling price of patentee's product minus the selling price of Lepton's product multiplied by the number of products sold by Lepton and the market share of the patentee. So the selling prices, we can find those two values on internet. However, it's relatively difficult to get the number of the infringing products sold by Lepton because this is not publicized. So anyway, we successfully found those information on Lepton's brochure, and it has 47 clients. And so even suppose one client for one infringing product, we could get 47. Also, for the market share, we located a paper written by two authors from Ministry of Science and Technology of China. And with that paper with the title Overview of the Czech nanotechnology industry shows that the market share of Elmarco in the field of nanospider is 17%. So with all those values, we calculated the losses of the patentee, which is far more larger than we claimed 5 million RMB. So finally, the court supported our claimed compensation, and well, that's why we got the 5 million. And now actually also prepared 2 slides about the claim construction, but I think it might be good to just stop there. And however, if you have any questions about this case or maybe any other IP issues in China, I would like to answer any questions in the Q&A session, and maybe also later after this session. Okay, thank you. Thank you very much for your attention.
Thank you very much, Bruce, for your very interesting presentation. Well, me personally, I know about the details, but I'm still surprised. I will start and open the Q&A session for you guys who are online. Like, there is the Q&A part of this session. You can place your questions. We will try to answer. I will start, Bruce, because, well, it really bothers me a little, makes me nervous. What would happen if Foshan Lepton continues in their doing? So if they still produce our type of machine, and what would happen to them? Are we going to again sue them again, or it's the very end of the story?
Okay, thank you, Masopust, for your question. That's actually very good question. And as we know that in this Lepton case, actually there are 2 forms of remedies for us. One is a compensation of 5 million, and the other is a permanent injunction to prevent Lepton from further infringement. And if Lepton refuses to pay the compensation, then we could ask an enforcement court to freeze the bank accounts of Lepton and transfer the awarded amount of money to us. And if there is no sufficient funds, then the court may auction Lepton's properties, including equipment or real estate, to fulfill its obligation. And Lepton's legal representative may also face personal consumption restrictions, like bans for air travel, high-speed rail usage, or luxury purchase until the obligations are finally fulfilled. On the other hand, if Lepton continues its patent infringement even after the judgment, as an entity, Lepton may face additional fines, and the legal representative could be charged under the criminal law. Also, for the continued infringement and for the losses, further additional losses caused by the continued infringement, a court could impose punitive damages up to 5 times of the patentee's losses. That is according to the new amendment Chinese law. Previously, there was no punitive damages, but now we have a punitive damages up to 5 times, even higher than 3 times punitive damages in US. That's basically so. So if Lepton does not comply with the judgment, there could be severe, consequences, including criminal punishment.
Thank you for that, Bruce. But there is one small question, even from Mike, I can see. Mike is asking about the official monitoring. Is there any like state monitoring of? And the question is, if Foshan Lepton creates a new company with some Foshan Lepton number 2, or I don't know, like some new name of the company, is that something like we have to monitor ourselves, or there is some state body who can monitor it?
Well, actually, actually that is a question that I previously asked by some clients. It's true that unfortunately there is no authorities to monitor further patent infringement of Foshan Lepton. We have to do it by ourselves, and by checking the legal representatives, or by to see the ownership of a new company, we can see maybe that is actually the same person who did the patent infringement again. Then we still could ask the court for punitive damages, and also maybe and also ask the administrative branches of the government to impose fines to that person.
Perfect, thank you. Thank you. Another question is, and it's from the auditorium. The question is, where to go first? Where is the first place if you find out that there is a patent infringement? So is like possible for me, like European guy, go to the Chinese court and say, well, look, like there is a patent infringement, like do something? Or is there any other place like I should go first?
It's okay. Actually, in China we have two parallel, ways to enforce your patent. One is the judicial way, as we did in this Lepton case, and of course we can, a European or maybe American patent owner could go directly to the court. But before that, you need to do some preparations, like collecting evidence regarding patent infringement and regarding damage calculation. And the sending of a warning letter is not a must for initiating a patent case before a civil court. That is one route. And then another route is you may go to a local patent office to ask them to do to take actions to prevent the patent infringement. But for that route, the timeline is more unpredictable. Sometimes I think some years ago I handled a case for a Taiwanese company, and theoretically the administrative route should be concluded within 1 year, but actually for that case, as I just mentioned, that proceeding is actually more unpredictable. It lasted for more than 3 years. So and also for that for the local patent office, there's only injunctive relief. There is no compensation. So typically, we would get a patentee to go to the court and file a patent case, and the result would be more predictable.
Thank you. There is another question from the auditorium, and it comes to me, honestly. It's about the money. If the legal cost was no higher than the than the penalty. First of all, it was not. Secondly, Mr. Haleš remembers that I told him years ago that it's not about money, it's about prestige, and it's about the case. So you could see everybody like Bruce informed us about that. This case is it's reported on the national level in China, and this is the thing. This is the thing for Elmarco. Honestly, it's not that much about the 5 mil. Of course, the 5 mil is fine, but will be perfect to get them. But it's about the prestige. It's about the name. It's about the sign. It's about to show the world, look, this company in Czech Republic will go to a court and will fight with you if you do something against us. And we are successful in that. So look at this. This is the important thing. This is the important thing. And of course, it costs some money. We knew what the cost would be, plus minus, and we were ready for that, and we were counting with that. So it's part of the bigger picture how we deal with the IPs. So just this is the answer. And there's another question to Bruce. If that situation or let's say a similar thing would happen the same way in Hong Kong and same way in China.
Well, the legal systems in Hong Kong is quite different, because I mean actually basically the legal system in Hong Kong follows the British way, while the mainland China follows the German way. So the litigation systems could be pretty different. But still, we have actually for our company, we have the headquarters in Hong Kong. We can also help you with the IP issues in Hong Kong. But frankly speaking, as you may know, that the litigation costs in UK could be much higher than the litigation costs in Germany. So similarly, a patent infringement case could cost much more in Hong Kong than the IP case in mainland China. That's that's basically the situation. But anyway, we can handle both cases in mainland China and Hong Kong.
I actually don't see any other question there, but I do have one more. And the question is about customers of Foshan. They bought it, they use it. Some of them, they call to Elmarco if they have some problem with hardware to fix it. So, well, that's kind of fun. Is there any problem for those companies who they bought this, and now they know that they made a mistake, but they know that they bought something which is illegal? Is there any legal problem for these?
Yeah, yes, of course. Actually, no matter those third parties, I mean the purchasers of the infringement products knows or doesn't know there is a patent infringement, they should bear the legal liabilities for patent infringement. Actually, according to Article 11 of the Chinese patent law, the patent infringement acts include manufacturing, selling, offering to sell, using, and importing infringement products. And if a third party purchases and deploys the infringement products of Lepton, it could be considered as a kind of using the infringement products, which constitute patent infringement. And they should bear, if we are serious about it, then we could ask for two forms of remedies. Firstly, the purchase of, the customers of Lepton should immediately stop using the infringing products. And secondly, they should pay compensation to the patentee, in this case, Elmarco. So there could be high risk to buy infringing products. And if infringing products are already, purchased by a third party, it might be good to immediately, stop the patent infringement, stop using the infringing products, so that they could earn some time to, adjust their business plan. Otherwise, the business could be, negatively influenced, severely. So that's why we in China, as a patent attorney, we also try to educate the Chinese companies, to follow the patent law and avoid patent infringement.
Thank you for the answer. I just want to say that we will not change our business model to get all the penalties from everybody who bought the machine from Foshan Lepton. Of course, we will fight, but still, we are our business is to do the solution for customers with our nanospider machine. Thank you, gentlemen. Thanks to David. Thanks to Bruce. Thanks for joining us. I believe this was very interesting session. I believe there were even some surprises, not only for the auditorium, but also for the audience, also for me. And I have to say that it well served the purpose. I do hope that everybody who was online could hear everything what they wanted. And of course, this webinar was recorded, so you can find it on our YouTube channel because our Elmarco Talks series is there. That's it for today. Thank you to everybody, and hear you next time with other topic, and very probably sometime in the future we will repeat this topic again because it was super interesting. Thank you very much to everybody.
Thank you.
Thank you, my pleasure.
Bye-bye.
Bye-bye.